to whom it may concern. Welcome to another stellar episode of Idea Defense 101. How's it going? Today we're going to give you a little glimpse into the patent application examination process. To do that, we're going to need the help of an inventor. Meet Joe Bliviss. Joe here has filed a patent application. We're going to use this to step through some of the common things that might happen to your application as it is examined. A patent application is not rubber-stamped or granted as a matter of course. An examiner at the U.S. Patent and Trademark Office trained in the relevant technology will review the application to make sure it complies with the rules. The most important job is to make sure the claims of your application meet the requirements of patentability, including a comparison of the claims to prior art, basically things that came before your application. The first action most applicants will receive from the office is a rejection of one or more claims of the application. This is usually because the examiner has determined that the claims are not new or are obvious over some prior art references. I knew it! I'm a failure! Why did I even try? I think you're overreacting just a bit, Joe. It's not really that big a deal. You get to respond to the rejection. Oh, I must look a little bit silly, huh? In some cases, perhaps the examiner misinterpreted the claims or misapplied the prior art, and you can submit arguments to that effect. In other cases, perhaps the prior art is a little too close, but you can amend the claims within the scope of your original disclosure to distinguish over those references. The examiner will review your amendments or arguments. If the examiner agrees with you, this may lead to the original rejection being withdrawn. However, the examiner is permitted to conduct further analysis, which may result in a second rejection. In some cases, that rejection may be made final. No! Why? Why? Are you always this dramatic? I was theatrically trained. You're theatrical, all right. Final doesn't really mean final. There are options for responding again, which typically require paying the patent office more money. You can also appeal the decision to the Patent Trial and Appeal Board, who will determine if the examiner was right or not. Bottom line is, this back and forth process will continue until you've convinced the examiner, either through arguments or amendments, that your patent claims meet the requirements for patentability. At that point, you get a notice of allowance. Whoopee! The upshot is, while some of the terminology may sound draconian, there is little reason to panic if your application doesn't get through the first time. Panic? Who's panicking? I'm not. Oh, what are you doing here? You're doing a patent episode without me? What gives? Love to answer that for you, but you know what? There's 3 of us here. You know what that means. Ooh, can we do it? Let's do it. All right. Let's go for it. Hello. Hello. Hello.